As of January 2026, multiple lawsuits have been filed by former state Senator Thomas Dwayne, residents, and tenant watch groups to block the New York City Housing Authority from demolishing and redeveloping the Fulton and Elliot-Chelsea houses in Manhattan. The redevelopment planned in partnership with Related and Essence development companies involved a $2 billion 99-year lease to demolish 18 buildings and replace them with new high-density mixed-income towers. Former State Senator Thomas Dwayne, along with 10 residents and the Midtown South Community Council, filed a lawsuit in the New York State Supreme Court. And the lawsuit claims the 99-year lease to a private developer violates a 2010 state law requiring Nycha to retain ownership and control of specifically listed developments, and that includes the Chelsea complex. The suit argues that replacing Section 9 public housing with Section 8 leads to reduced tenant protections, citing a 2024 comptroller study showing higher eviction rates from Nycha's privatized units. An earlier suit filed by residents alleging the project ignored the Uniform Land Use Review procedure known as the ULURP was dismissed in October of 2025 after a judge found it was largely generated by AI and included fake cases. Nycha sued at least 17 to 20 senior citizens for refusing to vacate their apartments in the Chelsea Addition building. And in November of 2025, Judge Emily Morales Minerva ruled against Nycha, stating that the authority provided no legal basis for forcing residents to relocate for modern amenities. Then in December of 2025, Judge David Cohen rejected Nycha's request for an emergency order to force the seniors out, allowing them to remain for the time being. Then there's the bait and switch, because residents and advocates argue that the original plan was for rehabilitation, but it is shifted to demolition, causing distress, particularly to elderly and disabled tenants who fear permanent displacement. And then there's the loss of rights, because the tenants argue that the plan to move residents from Section 9, which is traditional public housing, to Section 8, which they argue has weaker protections, as is evidenced by a 2022 Human Rights Report. Then there's the privacy and concern. Residents have complained of harassment, including the persistent knocking on their doors, stopped mail delivery, and pressure for the tenants to sign the relocation agreements. So while Nycha cites the $80 billion capital needs for repairs as a reason to rebuild, opponents argue that the new higher density buildings will destroy the neighborhood's character and create luxury, not truly affordable housing. The redevelopment is considered a key test case for the future of public-private partnerships in New York City public housing, with the city aiming to use this model to bypass its massive backlog. So the outcome of this case, if ending in Nycha's favor, will be the model being used across the board for any other development they seek to rehabilitate. So, all eyes on Chelsea Elliot-Fulton.